6:47 a.m., January 9th, 2026, Jacksonville, Florida. 14 U.S. Marshals moved through the parking lot of a residential complex on Hendricks Avenue, vehicles dark, engines off. 2 FBI Jacksonville field agents were positioned at the rear stairwell. A third unit held the perimeter on the street side. The target was on the 3rd floor, Unit 309. He had been living in Jacksonville for 11 days. Before that, Savannah, Georgia. Before that, a name that no longer legally existed. The warrant they were serving was 22 years, 1 month, and 14 days old. Inside the building, a property manager had already been escorted to the lobby. A neighbor's dog was barking somewhere on the 2nd floor. The marshals took the stairwell in 2 columns. At 6:51 a.m., they knocked on the door of Unit 309. The man inside opened it on the 2nd knock. His name, as of 2009, was David Crane. He was 51 years old. He worked as a paralegal at a mid-sized civil litigation firm in Savannah. He had a leased Hyundai in the parking lot downstairs. He had a mortgage application pending at a regional bank. He had been in the federal evidence database under a different name since November 2025. A latent fingerprint match returned in 72 hours. The marshal read him his rights at 6:54 a.m. Standing in the doorway, still in a grey undershirt, David Crane did not resist. He said nothing. He looked at the warrant in the marshal's hand, the way a man looks at something he has been expecting for a long time. Behind the arrest, behind the warrant, behind the 22-year gap, was one woman, a retired evidence clerk, and one mislabeled cardboard box. This is what happened. In the summer of 2003, the FBI Jacksonville field office was managing a federal racketeering investigation involving a mid-level drug distribution network operating out of Duval County. The DEA had been working the case for over 3 years. By mid-2003, they had enough to move. Indictments were being finalized. Grand jury proceedings were underway. One of the key witnesses was a woman named Carla Voss. She was 34 years old. She had worked as a bookkeeper for a business that, on paper, sold marine equipment. On paper. In practice, the business was a front for moving product through Jacksonville's port corridors. Carla Voss had seen the ledgers. She had seen the transfers. She had seen enough. She had agreed to testify. She was in the federal witness coordination process. She was not in protective custody. That determination had been made by a field supervisor based on the assessed threat level at the time. A decision that would later be reviewed and re-reviewed, though no formal finding of negligence was ever entered into the record. On July 19, 2003, Carla Voss was found dead in her apartment on Beach Boulevard, Jacksonville. The responding officers initially classified the scene as a possible suicide. She was found in her bedroom. The window was closed. The door had been locked from the inside, or appeared to be. The medical examiner's initial assessment was consistent with asphyxiation. The FBI opened a homicide investigation 48 hours later, after a forensic technician flagged inconsistencies in the scene documentation. There were fiber traces on her forearms, inconsistent with the bedding. A partial latent print had been lifted from the interior surface of the bedroom window frame. The window, the examiner noted upon re-inspection, showed scoring marks on the latch consistent with a tool entry in re-close. This was not a suicide. The investigation was assigned to 2 agents out of the Jacksonville field office. They worked it through the fall of 2003 and into the winter. They developed a short list of individuals with both the motive and the operational proximity to have known about Voss's cooperation. One name kept coming up. A DEA-adjacent informant who had worked the same distribution network from the other side, feeding information selectively and, it appeared, not always accurately. His name was Marcus Elroy. He was 29 at the time. He was not a DEA employee. He was an asset. One of hundreds of informal arrangements the agency maintained with individuals embedded in target networks. Elroy had access. He had been present at a coordination meeting where Voss's identity as a cooperating witness had been discussed in imprecise terms. He had motive. But the agents couldn't get past motive. The fiber samples required more processing time than the lab could accommodate given its backlog. The latent print card from the window frame, a single partial, had been logged into evidence but not yet submitted for analysis. The FBI's latent print unit in 2003 operated on a different submission queue system than what would be standardized in later years. The card sat in the evidence package. 14 months after the case was opened, in September 2004, it was administratively closed. Official designation: inactive, insufficient leads. The caseload at the Jacksonville field office had grown substantially. The DEA racketeering case had already proceeded without Voss's testimony. Elroy had disappeared from the informant network's active roster shortly after the murder, though this was not, at the time, connected to any investigative file. The evidence package for case file J034417 was sealed, boxed, and logged into the Jacksonville Field Office Evidence Warehouse. What the warehouse management system recorded, due to a data entry error made during the transition from one cataloging software to another in late 2004, was not open homicide. Inactive. It was logged under a category code for civil forfeiture surplus. 1 digit. 1 category code. The difference between a box that stays in reviewed rotation and a box that sits untouched on a shelf in a secondary storage section for decades. For 21 years, that is exactly what happened. Something about the size of that error. One wrong code, 22 years, doesn't sit right even now. Not because it was malicious. Because it wasn't. It was a number entered incorrectly on a Tuesday afternoon in November 2004 by a warehouse clerk who had no reason to double-check it. In October 2025, the Department of Justice issued updated federal records retention guidelines affecting physical evidence storage at field offices nationwide. The new policy required officers to conduct a full audit of materials held more than 15 years, cross-referenced against case status designations, ahead of a scheduled destruction review cycle beginning in early 2026. Jacksonville field office supervisors tasked several personnel with the audit, including contracting a number of retired evidence management specialists on a temporary review basis. Among them was Margaret Osei. Margaret Osei had worked in the FBI's Evidence Management Division for 31 years. She had retired in 2022. She was 67 years old. She lived alone in a house in Orange Park, south of Jacksonville, and had spent much of her retirement reading, tending a small garden, and occasionally consulting on archival matters for a county historical project. When the field office called asking if she would be available for the temporary audit engagement, she said yes without much deliberation. It was the kind of work she knew how to do. It was the kind of work she did not find tedious. She began her assignment in the second week of October 2025. Her role was specific. Review the secondary storage sections of the warehouse. The shelves holding materials classified under miscellaneous, surplus, and administrative hold categories, and flag anything that appeared mismatched with its designation. She worked methodically, from the oldest materials toward the newer. She wore reading glasses on a chain and carried a clipboard with a printed legend of category codes and their corresponding case type definitions. She did not rush. She had been retired for 3 years and had nowhere else to be. On October 28th, 2025, approximately 3 weeks into her engagement, she pulled a sealed evidence box from a shelf in the civil forfeiture surplus section. The box was dated November 2004. The external label read, Case Designation CFS 042218, Civil Forfeiture Surplus, MISC Physical Materials. She looked at the label. She looked at the date. She looked at the box's physical condition. Sealed with evidence tape, initials on the tape seal, chain of custody tags still attached to the handle. Evidence tape on civil forfeiture surplus materials was not standard. Civil forfeiture surplus boxes typically contained asset documentation, photographs of seized property, or financial records, not physical evidence requiring sealed chain of custody handling. The tape and the tags told her this was not what the label said it was. She flagged it. She did not open it. She marked it on her clipboard and at the end of the day brought it to the attention of the current evidence unit supervisor, a special agent named Robert Keel. Keel pulled the box's entry from the warehouse management system, CFS 042218, Civil Forfeiture Surplus. He ran a cross-reference against the case numbers adjacent to it in the 2004 entry log. The entries around it in the original sequence were labelled J034417 through J034420, all homicide case designations from 2003. The gap was obvious once you looked for it. J034417 did not appear in the warehouse log under any current designation. What had been assigned to case J034417 in 2004 had been entered under a civil forfeiture code instead. Keel pulled the original case file from the inactive records archive. Case J034417. Victim, Carla Voss. Classification, homicide, open. Administratively closed September 2004, insufficient leads. He opened the box. Inside, a sealed evidence envelope containing fibre samples on collection cards, a second envelope with swabs, and one latent print card, sealed in a paper envelope, logged as evidence item J034417 LP01. Lifted from the interior surface of a bedroom window frame, Jacksonville, Florida, July 2003. It had never been submitted to the lab. The latent print card was submitted to the FBI's Next Generation Identification System on November 3, 2025. The system returned a match on November 6, 2025. 72 hours. The match was to a fingerprint on file under a different name. The legal name change had been processed through a Florida county court in 2009. The original identity tied to that print, Marcus Elroy, former DEA-adjacent informant, last known active in the Jacksonville area in 2004. The current registered identity, David Crane. Current address, Savannah, Georgia. Employer, a civil litigation firm where he had worked as a paralegal for 6 years. The match was not a partial. It was a 14-point ridge comparison. The print from the bedroom window of Carla Voss's apartment in July 2003 belonged to the man now living as David Crane. I spent hours going through the case reconstruction documents, and one detail kept nagging at me: the window. The staging had been careful. The door had been locked from inside through a standard mechanism manipulation, achievable with a thin tool pulled from the outside before the door closes. But the window had been opened to allow exit and then relatched from outside, using the same tool. On the interior surface of that latch, on the metal housing that a gloved hand would have pressed to hold steady while manipulating it, one print, one partial, left through a gap in the glove at the base of the thumb. One small moment of contact, 22 years of silence. And then a retired evidence clerk with a clipboard noticed that the tape on the box was wrong. The FBI Jacksonville Division opened a formal reinvestigation of case J0-34417 on November 10, 2025. The case was active for the first time in over 2 decades, and for the first time ever, it had a named suspect. Special Agent Dana Markham was assigned as lead agent. She had been with the Jacksonville field office for 9 years. She had worked cold cases before, though not one this old. Her first task was to establish what David Crane, formerly Marcus Elroy, had done with the 22 years between Carla Voss's death and his current life in Savannah. What she found was not dramatic. It was largely ordinary. After leaving the informant network in late 2003, Elroy had moved between several states. He worked construction in Georgia, then property management in South Carolina, then a series of administrative roles. He attended a paralegal certification program in 2007. He filed the name change petition in 2009, listing personal reasons in the court documents, a category that requires no further explanation under Florida law. He had not been arrested in the intervening years. He had not surfaced on any federal watch list. He had simply become someone else. Here's what this tells us about the case, and about how witness security failures of that era operated. There was no system in 2003 that would have cross-referenced an informal informant's name against a homicide investigation that itself was administratively closed within 14 months. Elroy was not a primary suspect who had been charged and fled. He was a background name in a closed file. When the file closed, so did the tracking. The legal name change in 2009, 5 years later, passed without any flag because there was no active warrant and no open case to trigger one. The system didn't fail in one moment. It failed in increments. Each individually defensible, each individually small, each one adding to a 22-year total. Special Agent Markham's investigation moved carefully. She was building a case that would have to withstand scrutiny from a defense team that would immediately argue contamination, evidence degradation, and chain of custody gaps across 2 decades. Every procedural step had to be clean. The fiber samples from the original evidence envelope were submitted to the FBI laboratory in Quantico. The question, could the samples still yield viable data after more than 2 decades in sealed storage? The lab's response, returned on November 24, 2025, was qualified but significant. 3 of the 7 fiber samples had degraded below useful analytical threshold. 4 retained enough structural integrity for comparison analysis. Of those 4, 2 returned profiles consistent with a synthetic blend used in work gloves common in the early 2000s. Generic. Useful for corroboration, not identification. The latent print remained the primary evidence. What's most surprising about this case isn't the print match. It's what happened when Markham began reconstructing Elroy's movements in the summer of 2003. Court records, DEA coordination logs from the period, and a surviving administrative memo from 2003, recovered from a physical archive, not a digital system, showed that Elroy had been present at a coordination meeting on July 9, 2003, 10 days before Voss's death. The meeting had included 2 DEA case agents and a federal prosecutor. The topic was trial scheduling and witness logistics. Voss's name did not appear in the surviving memo, but the memo referenced the Buchanan Street bookkeeper, an identifier specific enough that anyone with knowledge of the network would have known immediately who it described. Elroy had been in that room. The DEA coordination records from 2003 were partial. Some had been destroyed under prior retention cycles. The two case agents from that era were no longer with the agency. One had retired, one had died in 2018. The federal prosecutor who had run that meeting was now a judge in a different district. Markham interviewed each of the living parties. Each confirmed the meeting's existence. None could confirm what Elroy had said or who he had spoken to afterward. The gap in the documentary record was real, but the print from the window was real too. In December 2025, the United States Attorney's Office for the Middle District of Florida reviewed the case package assembled by Markham's team. The evidence, the latent print match, the fiber corroboration, the circumstantial connection through the July 9th meeting, the name change documentation, and the timeline of Elroy's departure from the informant network in the weeks following Voss's death. The U.S. Attorney's Office authorized the presentation of the case to a grand jury. Proceedings began on December 15th, 2025. The obstacle Markham's team faced during the grand jury preparation was significant: the defense of chain of custody. The evidence box had sat in a mislabeled section of a warehouse for over 20 years. No lab submissions, no re-inventories, no verification checks. The defense, once appointed, would argue that the isolation of the evidence from proper storage protocols, even if unintentional, created a reasonable question about integrity. Markham addressed this directly in her grand jury testimony. She walked the jury through the physical condition of the evidence upon opening: the tape seals intact, the chain of custody tags unbroken, the initials on the tape matching the inventory sheets from 2003. She presented testimony from the FBI laboratory regarding the condition of the materials and the absence of any indicators of tampering or contamination. She presented Margaret Osei's account of how she had located the box, what she had observed, and why she had flagged it rather than opening it herself. The grand jury returned an indictment on January 6, 2026. The charge, murder in aid of racketeering, under 18 U.S.C. Section 1959. A federal charge, not a state homicide charge, which meant federal prosecution, federal sentencing guidelines, and no statute of limitations. The warrant was issued on January 7, 2026. By that point, surveillance had already confirmed that David Crane, Marcus Elroy, was no longer in Savannah. A check on his apartment, conducted by agents from the FBI Savannah resident agency on January 5th, found the apartment still occupied. His vehicle was still in the lot. He was working reduced hours at the firm due to what he had described to colleagues as a minor health issue. He had not left the country. He was not running. He may not have known yet. Or he may have suspected and decided that running after 22 years of successfully disappearing was no longer a viable option. On the morning of January 9th, 2026, 14 U.S. Marshals and 2 FBI Jacksonville field agents served the warrant at Unit 309 of a residential complex on Hendricks Avenue, Jacksonville, Florida. Elroy had relocated to Jacksonville 11 days earlier, citing a lease termination at his Savannah apartment. The relocation appeared to have been planned weeks in advance. A lease signing at the Jacksonville complex dated to early December 2025. Put yourself in Markham's position for a second. You're leading an operation to serve a murder warrant on a man whose identity has been legally altered for 16 years, who has been law-abiding by every visible measure since 2004, and whose defense team is going to scrutinize every element of a 2-decade-old evidence chain. The warrant is clean. The print is clean. But you are serving it on a man who, until November 2025, did not technically exist in any federal homicide file. That is a complicated morning. At 6:54 a.m. On January 9th, 2026, David Crane, Marcus Elroy, was placed under arrest and transported to the Duval County Correctional Center, pending his initial appearance before a federal magistrate judge. He said nothing when the warrant was read. He said nothing during transport. His attorney, appointed after the initial appearance, entered a not guilty plea at arraignment on January 13th, 2026. Here's the part that doesn't make sense on the surface. Elroy's departure from Savannah in December 2025. The months in advance lease signing in Jacksonville suggests possible awareness that something was moving. But what awareness? The grand jury proceedings were sealed. The lab submissions were not public. The FBI reinvestigation had no public designation. There was no press coverage, no social media trace of the case. One possibility considered by the investigative team and documented in post-arrest reporting: Elroy had been watching the news. In October 2025, several media outlets reported on the DOJ's new federal records retention guidelines and the field office audit requirement. The story was not widely covered, but it appeared in a Justice Department press release that several legal news aggregators republished. A retired paralegal, a man who spent his working days reading legal documents, might have noticed it. Might have understood what a physical evidence audit at Jacksonville could mean, specifically for him. If so, he had known since October. He had not run. He had moved 90 minutes up I-95 to a city where he had no prior associations. Whether that constitutes flight or simply a man trying to re-establish himself while hoping the audit found nothing is a question for the jury. The trial date had not been set as of the time this account was compiled. Pretrial motions are expected to address chain of custody arguments, the admissibility of the 2003 DEA coordination memo, and the legal standards for latent print evidence submitted 2 decades after collection. The defense has not publicly commented on the evidence. Early procedural filings suggest the expected challenges. What do you think? Did the system fail Carla Voss because of the mislabeled box, or because of the circumstances that led to that box existing in the first place? The question matters because this case is not really about Marcus Elroy finding a way to disappear. It is about a system that, under the pressures of the 2004 caseload environment, closed a homicide file without processing its own evidence. The latent print card was collected correctly. It was logged correctly. It was sealed correctly. It was simply never sent to the lab because the case was closed before the submission queue reached it. And then the box was mislabeled, and 22 years passed. The evidence was there the entire time. The administrative closure of case J0-34417 in September 2004, 14 months after a federal witness was murdered, was premature. It reflects a resource allocation failure the institution has never formally acknowledged. The decision was documented as insufficient leads, but the leads were not insufficient. The evidence had not been fully processed. The lab submission had not been made. What was insufficient was the time assigned to the case before the pressure to reduce the active file count took precedence. That is a different thing. The 22-year gap in this case belongs to more than one mistake. Margaret Osei returned to Orange Park after her final day of the audit engagement in late November 2025. She was not present for the grand jury proceedings. She was not in the parking lot on Hendricks Avenue on January 9th, 2026. Her role in the case was precisely this. She noticed that the tape on a box was wrong, and she told the right person. In the FBI's formal case reconstruction, her name appears once in the evidence chain, at the point of initial rediscovery. Her statement, taken in late October 2025, is 4 pages long. It describes what she saw, what she did, and why she flagged the box rather than moving on to the next shelf. She told agents she had flagged it because evidence tape on a civil forfeiture box was not correct procedure. That was all. She did not know what was inside. She did not know the case number. She did not know the victim's name. She knew that the tape was wrong. The case of Carla Voss, case J0-34417, is scheduled to proceed to trial in the Middle District of Florida. The United States Attorney's Office has designated the prosecution as a high-priority federal homicide case. The lead prosecutor has handled 3 prior racketeering-adjacent murder cases, all of which resulted in conviction. The defense, by all indicators, will contest the print, contest the chain of custody, and contest the sufficiency of the circumstantial evidence connecting Elroy to the July 9th meeting and the subsequent murder. These are legitimate trial arguments. The jury will hear them. What the jury will also hear is the account of how a single evidence box survived 22 years of mislabeling, 2 software transitions, multiple retention reviews, and a scheduled destruction cycle, and arrived intact, with its chain of custody documentation unbroken, in the hands of a forensic laboratory that returned a match in 72 hours. One detail stuck with me through all of the case documentation: the chain of custody tags on the evidence box. They were initialed by a technician named R. Dolan, Jacksonville Evidence Unit, November 2004. Robert Dolan retired from the FBI in 2015. When Markham's team interviewed him in November 2025, he remembered the case. Not the specific box, not the specific tags, but the general circumstances of 2003 and 2004. He said he initialed a large number of evidence packages during the software transition period. He said he always sealed everything the same way, regardless of what it would be labelled as in the new system. He said the sealing was his job, and the labelling was someone else's. He was right on both counts. The seal had held for 22 years. The label had been wrong for 22 years. Neither of those facts is separate from the other. The victim's family, identified in the case file but not named in public court documents, was notified of the arrest in January 2026. According to the U.S. Attorney's Office, they were informed of the circumstances of the evidence recovery, including Margaret Osei's role. The family's response is not part of the public record. The DEA racketeering case that Carla Voss had agreed to testify in was resolved in 2005 without her testimony on the basis of other evidence and cooperating witnesses. 3 defendants were convicted. 2 served federal prison sentences and have since been released. 1 remains in federal custody on unrelated subsequent charges. None of the 3 were Elroy. Elroy had never been charged in connection with the racketeering case. His role had been as an informant, not a defendant. When the case closed and when the homicide file closed, he was simply gone from the record. The man who murdered a federal witness in July 2003 spent 22 years living an ordinary life. He changed his name legally and correctly. He built a professional career in a field that required background checks. He paid his taxes. He signed a lease. He applied for a mortgage. He was 71 minutes from the city where he had committed the crime because he relocated 90 minutes north on the interstate in December 2025. If the audit had not occurred, the destruction review cycle would have reached the civil forfeiture surplus section of the Jacksonville warehouse in February 2026. Case J034417, still mislabeled, would have been flagged for destruction under the standard retention policy. The box would have been pulped. The margin was not 22 years. The margin, by the time Margaret Osei pulled that box off the shelf in October 2025, was approximately 3 months. Will a case like this surface again from another field office, another mislabeled box, another audit? Comment why yes or no, because the DOJ's new retention guidelines apply to 49 other field offices currently conducting the same review. The arrest of David Crane on January 9th, 2026 closed the warrant. It did not close the questions. The DEA coordination records from the summer of 2003 remain incomplete. The individuals who attended the July 9th meeting and who may have interacted with Elroy afterward, informally, off the record, in hallways rather than conference rooms, cannot be fully reconstructed from surviving documents. Whether Elroy acted alone, whether he was directed by someone within the network, whether the staging of Voss's death reflected his own planning or a methodology provided to him. These are questions the trial may answer or may not. If the trial produces a conviction, sentencing under federal statutes for murder in aid of racketeering carries a mandatory minimum of life imprisonment. There is no parole in the federal system. If the trial produces an acquittal on chain of custody grounds, the state of Florida retains jurisdiction to prosecute under state homicide statutes. The statute of limitations for first-degree murder in Florida was abolished for cases occurring after 1984. The evidence would transfer to state prosecution. Either way, the warrant is served. The file is no longer closed. What stays unresolved is the network itself. The racketeering operation that Carla Voss had agreed to expose in 2003 was prosecuted, but the investigation was limited to what was already known at the time of indictment. Voss's testimony, the testimony that was never given, reportedly included material about distribution channels and financial routing that extended beyond the 3 defendants who were ultimately charged. That material died with her. What it would have added to the prosecution, what it might have traced, who else it might have implicated. No one can reconstruct that from the outside of what was known and sealed 2 decades ago. The network was dismantled in 2005. The demand that created it still exists. And somewhere in the gap between what Carla Voss knew and what was ever formally documented, there are names that were never in the file. The box is open. The evidence has been processed. One retired clerk with a clipboard noticed that the tape was wrong. If you've followed cases like this one before, cases where a single administrative error cost a family decades, subscribe to Cold Warrant. The next file is already pulled.